State of Florida is now in session. The Honorable James A. Edwards, Judge, presiding. All persons that have business before this court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, this honorable court. Please be seated.
Good morning, everybody. I've been introduced. My colleagues today on the bench, as you can see from the signs on the bench, are Judge Makar to my right, Judge Harris to my left. We have 3 cases on the docket this morning, but we're going to have a panel change, so we'll have a short recess right after the first case. The way our system works, we have little traffic lights up there for you to see. Green means you're good with your time. Yellow means for the appellant you're into your rebuttal time. Red means stop. And we really like it when you stop. If I see you're getting into your rebuttal time as the appellant, I'll try to let you know. But it's your time. You can use it however you want. The 20 minutes per side, that's what's showing on the clock. You don't get 20 plus 5 more for rebuttal. And for the appellant, please let me know if you want something other than 5 minutes. That's typically what we reserve. If you have a noisemaker like a telephone or a computer that's going to make noise, please put it on silent or vibrate because it's guaranteed to go off at exactly the wrong time. So with that, we'll have our first case, which is 25-2370, Staker and Bell versus JEA.
Good morning, Your Honors. Jordan Lipkanen for plaintiffs' appellants Kim Staker and Earl Bell. I'd like to reserve 5 minutes for rebuttal.
Okay.
This suit raises a simple question of statutory interpretation. It does not ask nor require that this court delve into the completely extraneous topics of rate making, balancing JEA's charter and statutory duties, or opining on the value of solar. The sole issue before this court is whether JEA, acting in its proprietary capacity, unlawfully terminated its net metering program in violation of Section 366.91 Florida statutes.
So it's all about what does offset mean, right?
That's exactly right, Your Honor.
Okay.
And we would say that offset means a 100% offset. The statute is not modified in any way. If we can turn to the definition, that's really at the heart of this. Net metering, this is 366.91 D. Net metering means a metering and billing methodology whereby customer-owned renewable generation is allowed to offset the customer's electricity consumption on site. So offset there is not modified. It's not partially offset. It's not offset somewhat. And more importantly, it is not about offsetting
Counsel,
value.
it doesn't say offset entirely either. If it said offset entirely, you've got a pretty good case. It just says offset.
You're absolutely right. It does say offset. The legislature, I think, thought it was clear enough that they did not need to say completely offset. If you look just one definition before, in the definition for customer-owned renewable generation, this is 2C. That is defined as an electric generating system located on a customer's premises that is primarily intended to offset part or all of the customer's electricity requirements. That definition is important for 2 reasons. One, we're again talking about offsetting energy, not offsetting value, not offsetting money, not crediting, but offsetting energy. And 2, the legislature saw fit there to specify all or part, and they did not just one definition later when they said that it means offset with no modification.
Well, D actually focuses on electricity consumption, correct? It's an offset of the consumption.
Well, they're 2 sides of the same coin. So C is talking about the equipment that allows you to generate the electricity that is offsetting your consumption. D is talking about net metering as the methodology that has been selected by the statute that the utilities are tasked with developing a program to implement, but specifically not just any program, but a net metering program. And it defines
so to simplify your argument, the offset means, well, in C it says offset part or all. So therefore you say because they didn't use the phrase part or all in D, therefore it must mean all.
Yes, that's right.
Okay.
So if maybe to help understand this better, offset is not modified by the statute, so we give it its plain meaning. And the plain meaning of offset is to balance to make it, to counterbalance, to make it so there's no great result or no great difference in the result, to balance one opposing influence as to the other. The idea here is that offset means like for like, and under net metering, you are supposed to be offsetting energy. That means that every kilowatt hour of electricity that is generated by a rooftop solar system should, on a one-for-one basis, offset electricity from the grid. The reason we say it has to be one-for-one, even though it does not say one-for-one expressly in the statute, is because it's talking about energy. So under the exact net metering program that other utilities offer and that JEA used to offer before 2018, a kilowatt hour of electricity that came from a rooftop solar system was credited at the retail rate, which means when you take a kilowatt hour from JEA system, you pay the retail rate, and when you send a kilowatt hour to JEA system, you pay the retail rate. Because it's the same exact rate, now you're offsetting energy rather than offsetting money. The issue is that when JEA moved to offsetting, when JEA moved to end its net metering program and replace it with this new scheme where it credits at the fuel rate, now you are taking at 100% the cost of a kilowatt hour, and you are receiving, or you're taking from the grid at 100% the retail cost, and JEA is paying you at about a third of the retail cost. And so you can't say that it's offsetting, or that it's balancing out, that it's counterbalancing, that it's preventing some great difference in result, if you are getting 38 cents on the dollar and calling it a fair trade.
What was the retail, or what was the value of the retail rate for, say, calendar year 2025 or 2024? In other words, how much money are we talking about collectively at JEA between the retail rate for one particular year for everybody in JEA's jurisdiction versus the new fuel cost?
I would have to check that, but I want to be very clear that the retail rate is not challenged by any party in this case. My clients are not suggesting that the retail rate should be any higher or lower. They're not suggesting that the fuel rate should be.
They're happy with, they want that.
They want JEA to follow the statute, which requires JEA to credit them at the same rate that they are charging them for electricity taken from the grid. So
what percentage is it now? In other words, if they got the retail rate before, let's make that 100%, but now they're only getting the fuel cost. Is that like 40%?
The last time I checked, it was a little under 40. It hovers around a third. It basically has to do with whatever JEA is paying for fuel at a given time, and that is also what causes the retail rate. I think it's the thing that most influences the retail rate moving up and down from month to month. And the idea here is our clients are completely agnostic as to what the retail rate is and what the fuel rate is. In fact, we don't think it would be appropriate for our clients to challenge the monetary amount of the retail rate unless we thought that independently was violating Florida statute. JEA has the discretion to set its retail rate where it wants to. The issue here is that JEA is trying to do what it cannot under Section 366.91, which is use a different rate. And that takes us out of a rate-making idea and into a rate structure idea, which is emphatically under the purview of this court to review.
What is the idea in 366.051 where they talk about a utility's full avoided cost? How does that factor into metering?
Yeah, that's an excellent question. So we use fuel cost and avoided cost as near synonyms, but that's not quite right. The fuel cost or the fuel rate is the predominant component of a utility's full avoided cost.
Because you could have a railroad car full of coal and you don't get any electricity, right?
That's right. You're also recognizing that there's a capacity cost, that there's other things that go into making the electricity. It's not just, if I give you a mountain of coal, you can make me some electrons. And so under statute, 366.051 defines that full avoided cost, and it gives some additional things to think about, such as an avoided unit. The idea of an avoided unit there is, this is the coal plant or the gas plant that JEA would have had to build, but for being able to get that electricity from a different source. So we're not taking specific issue. Well, we do, but it's not the focus of this case. The way JEA is defining...
That's pennies, basically, compared to 70% or 65% or whatever.
Well, I think the real issue that the fuel cost versus the avoided cost is very important for understanding here is if you look at the 2022 legislation that would have, for public utilities, phased out net metering completely and replaced it with a system that is almost identical to what JEA has, that talks about the avoided cost. But there's another one as well that talks about the avoided cost, and that's under 36691 subsection 4. This is a pre-existing duty that remains in place until this moment for JEA to purchase, not offset, not credit, but to purchase electricity from renewable generators at its full avoided cost rate. That is still in the statute. That does not conflict with net metering because it's for a different posture. That's more for qualified facilities under a PURPA idea. And the idea really is you can buy up 10 acres of land, slap up a bunch of solar panels, and JEA is required to buy that electricity from you. But they are only required to buy it from you at their avoided cost rate. When the legislature, 3 years after enacting that subsection, enacted the net metering subsection that applies to JEA, which is subsection 6 in 2008, that specifically says net metering, and it says offset energy, not credit value. And I think that's really what the center point of our case here is that when you hear JEA talk about these fairness arguments, what really goes into their costs, the fixed versus the variable, I would like to state very emphatically for the record that these are not uncontested facts. So we have contested those facts in an affidavit by our witness, our expert, Carl Rabago. But the disagreement on those facts is completely immaterial to the actual issue at hand here, because all of that goes to value. JEA can determine that the value to it of a kilowatt hour of energy received from a rooftop solar unit is only worth the energy cost that it's offsetting. That's up to JEA. But the problem is that when JEA then says we're only going to pay you for what we think the value of that kilowatt hour is, now they're violating the statute, because the statute does not traffic in terms of offsetting value. It traffics in terms of offsetting energy. And so if JEA wants to pursue a system where they are compensating rooftop solar customers for the value to JEA's system that they perceive it to be, that requires a rewrite of the statute. And that is exactly what happened in 2022 when the investor-owned utilities went to the Florida legislature and they tried to get rid of net metering for their utilities.
That's the legislative history of a statute that didn't get signed into law.
That is correct. It was not signed into law, Your Honor.
I'll just ask you this. It seems to me JEA is making an argument that customer-generated solar power became too popular. Too many people wanted to do it. Therefore, we have an excess available to us, and that's why we had to cut back on the price we were reimbursing people. That seems to kind of run through their brief and through some of their argument. If there weren't as much customer-generated solar power being sold to JEA, was there anything in the record about how much additional capacity they would have to have in terms of additional generation, additional buildings to store the generators, additional employees and all that, in terms of what their non-fuel cost would have to be, but for the solar power coming from customers?
It's an excellent question, Your Honor. No, there is nothing in the record to this point, and that is exactly because both JEA and the appellants in this case agreed from the outset that the only factual things that mattered here were, are the clients that we are representing JEA customers? Did they install rooftop solar systems? Are they interconnected with JEA's grid? And is JEA compensating their excess solar capacity or their excess solar generation at the fuel rate rather than the retail rate? The answer to all of those questions is yes. That's the end of the material facts. And so when I talk about these other things that we are contesting, they're not material to the record. So neither party saw the need to go through rigorous discovery to develop a factual evidentiary basis for what the value should be, because again, we go right back to the statute, which says offset energy. And so it doesn't matter what the value to JEA's system would be. I recognize that the 2022 legislation, while it was fully passed by both houses, was vetoed by the governor, and we celebrate that decision because we think the governor got it right there, that we shouldn't get rid of net metering. But that was exactly what the legislature was trying to do, was to take on the exact kind of arguments that JEA is raising here. Those are completely appropriate arguments for JEA to make, just not in this forum. JEA's recourse is with the legislature, not with the courts, and not with self-help to redefine
Do you see that as a credit for excess generation? Is that what you call what the legislature was trying to do that got vetoed by the governor?
The 2022 legislation?
Yes.
Yes, and in fact, if you look at some of the sponsor statements, all the sponsors in both houses are very clear that the status quo ante, when they were introducing that legislation, was that you had to compensate at the full retail rate. I can give you quotes if that's helpful, but you can also take on representation. That's what they were all saying. And this was clear in the staff analysis. It was clear in everyone that understood. It was clear at that time that that was the issue that they were trying to address. And you've got sponsors making statements about the value of the solar energy and it being too high because it's not taking into account these capacity costs and the other fixed things, the exact arguments that JEA is making. That is why the legislature was undertaking to change the statute, because they believed those same arguments. That's the appropriate form. If JEA wants to also have net metering go away for it, that's the place where it has to go. But what it's doing now is asking you to redefine the statute. It does not say 100% offset because the legislature did not feel that they needed to specify that offset. It certainly doesn't say any offset.
JEA also makes the argument that the rates have to be fair, just, non-discriminatory, and about 5 other different words. And they're saying that because most customers with solar generation panels are affluent, therefore the poor are having to prop up the rich in terms of this. Does that come into play in the statute at all?
Frankly, Your Honor,
whether it's true or not?
So there's 2 questions there. Let me take those separately. Your second question, is that in the statute? No, that's not in the statute. The statute just says provide net metering. It doesn't say provide net metering until you decide that it is economically disadvantageous or that it's creating problems for your utility. In fact, there are things in the statute that make clear that this is meant to go on in perpetuity, such as filing an annual report on the net metering energy that on the energy that you've net metered over the past year, the total participation, et cetera. But you can also look right at the first subsection of this statute that says the purpose, the whole point of 36691 is the legislature saying we want to see more solar on the grid, and we have designated net metering as the way to incentivize it. So to the extent that JEA is upset that the statute is functioning as intended, again, that's a question for the legislature to say, hey, it seems to have done what you wanted to do, now we would like to change it. But that, again, is not appropriately put to this court. And to the first aspect of that question, going to, I apologize, could you redirect me to the beginning of that? Or
that's all right. You're into your rebuttal time. If you want to
I'll save
ponder it or have your colleague there remind you what the question is, that'll be fine.
Thank you very much.
Thank you.
Good morning, Your Honors. Laura Beckman on behalf of JEA. JEA is complying with the statutory requirements of 366.91 because it developed a developed a net metering program for customer-owned renewable generation. This statute provides JEA with the discretion for how to develop that program, but that discretion does not make it ambiguous. The clear statutory language of 366.91 allows JEA to determine how best to reimburse customers for the energy that it takes. There's nothing in 366.91 that addresses the fuel rate versus the retail rate. Those words do not appear in this statute.
Under 366.91 2D, net metering refers to a metering and billing methodology. So when I think of billing, I think of money. Do you?
Yes, Your Honor.
Okay. So when it talks about offset the customer's electrical consumption and billing, you're talking about how much to reimburse or pay the customer or offset the customer's bill, right?
Correct.
In the subsection C just above that, as counsel pointed out here, and in its brief repeatedly, they use part or all in subsection C when they're talking about generation. They do not qualify it at all in subsection D. So how do you counter his argument that if it's not qualified, it must mean equally 100%, 1-to-1, whatever else you want to mean back in the old days when it was full retail?
So first of all, there is nothing in the statute that says that offset means a 100% 1-to-1 reimbursement.
Well, if it didn't mean 1-to-1 or full offset, why does it have to be qualified in subsection C?
I think it goes back to subsection 6, which is really the part of the statute that we're dealing with here, which is the directive to the municipal electric utilities to develop a net metering program and for customer-owned renewable generation. So both the definition of 2C and 2D are incorporated into what JEA must do. And so I understand the point. They've said offset part or all in C, but not in D. But D still doesn't directly address whether that offset has to be a 1-to-1 or a 100%. And so can offset part or all of the electricity requirements in C does not mean that net metering has to be a 100% offset on the billing as well.
Well, in the utility world, I mean, there can be various costs. You can have retail, whatever is on the bill. You can also look at the utility and say, well, we're going to charge the marginal cost. You know, as you produce more energy, it costs more. The marginal cost of doing so. You have the fixed cost of the plant and the marginal cost of fuel. Then you have average cost. You might have average variable costs. So there could be a number of different ways in the utility world, and here electrical utility, by which a utility prices its product, or determines not just the pricing, but also determines the cost of its product. So I'm struggling, and I'm not sure where I'm leaning, but I don't see where the legislature has specified exactly what is to be done, and that we have to kind of infer, oh, it's all. I'm just not, there's nothing in the statute to me that jumps out and says, this is what the rate must be.
Well, and so I think, excuse me, if the legislature had intended JEA to have to do a 1-for-1 offset, it should have stated so.
Well, I think they're saying that if they produce energy, you've got to buy it, right?
And we do.
Right. Okay, so whatever amount, whether this is their normal monthly electric bill and they produce a lot of energy and they only have that much because they produced all this, you have to buy the extra that they've produced. But what if they go over? That was a question we were talking about behind the curtain earlier.
If they generate more than they use in a given month,
Yeah.
I mean, that would,
Would you buy that, or did you offset that?
so my understanding is that it happens like on a daily basis, that, you know, typically you generate more solar power during the middle of the day when the sun's out, and then you're pulling from the grid in the evening when there is no sun. And so I think at the end of the month, they net that and say, okay, how much did you use versus how much did you contribute? And I think as a general matter, you're using more than you're contributing, so that's why you still owe money at the end of the day. I'm not aware of a situation where they've completely subsidized all their own power use and had left over to send back to the grid.
Does JA have multi-part rates, meaning some utilities will have a rate that's very high during peak demand, where demand is very high. They'll have a higher rate. So if you want to use air conditioning in the afternoon, it's going to cost you. If you want to use it at 3 in the morning, it's not so bad. Is that something that JA uses?
Yes, that's my understanding, and that's, that goes again to rewarding the customers who focus on conservation, who run their dishwashers at night, who try not to use the electricity during the peak hours, that they get the lower rates. Not only should the legislature have to specifically tell JEA if they are supposed to be doing something other than what they're currently doing, the statute is silent as to whether it's the fuel rate or the retail rate. And that gives JEA the discretion for how best to implement this statute.
Let me ask you this, counsel. Before y'all changed your billing from full retail reimbursement to now fuel cost, has there been a change in the statute in terms of defining what offset is?
Not that I'm aware of, Your Honor.
Okay, so with the statute, in terms of that being the same, JEA started out saying it's 1-to-1, it's retail to retail. Nothing changed with the statute, but JEA said, as I mentioned before, there's so much of this solar power being sent to us, we can't continue to do it at retail 1-to-1, correct?
Correct.
But there's been no change in the statute. So how do you come up with two different meanings?
Because if we look at the statutory scheme as a whole, 366, multiple other provisions within 366 tell JEA that our rates have to be fair, reasonable, and non-discriminatory.
Okay, is it fair that the solar people, I call them solar, the consumers producing solar or generating solar power, as I asked counsel for the appellant, if there wasn't all this solar power, wouldn't JEA need more generators, more buildings, more people? So aren't those people, I mean, in your brief, you say they're getting an unfair free ride. Aren't they, in fact, subsidizing JEA's operation for everybody by, you don't have to have, whether it's 2 more or 20 more generators.
I would not say they're subsidizing, Your Honor. I'd say they're paying their fair share. So the extra energy.
But for the solar power, do you agree, and I don't know if it's in the record, but I mean, just common sense, you would agree, but for the solar power, y'all might need additional generation equipment?
It's not in the record, Your Honor, but I don't know that that's accurate because my understanding is that the solar power that's generated by customers who own solar is a very minuscule amount of energy that's actually contributed back to the grid.
Well, then why is it so deleterious to the budget of JEA that you won't be self-sustaining if you continue to pay it 1-to-1? That's part of the argument. You don't come right out and say that, but you say you have to be self-sustaining, which to me, I take that as a hint. We're paying too much out, we're going to go under, we can't be self-sustaining if we continue to do that.
Correct, Your Honor, because if we say $10 for a kilowatt hour, $77 of that $10 is JEA's cost for the infrastructure. But for JEA having that infrastructure in place, the excess energy that a solar power customer would generate would just go to waste. It wouldn't have any.
Talking about fuel cost, again, you got a railroad car full of fuel, whether it's diesel fuel, liquid propane, coal, whatever it is, you can sit there all day and look at it and it's not going to produce 1 kilowatt of hour, whereas something running does. There are maintenance costs for that, there's repair costs for that, there's replacement costs for that. Those are all incremental costs that JEA incurs every time it generates a kilowatt hour, yet y'all are reimbursing only for fuel.
But those costs exist whether we get the energy from the solar-powered customers or whether we generate it on our own. The solar-powered customers would not be able to use solar power but for the infrastructure that JEA provides them.
You couldn't use the solar power but for the infrastructure that the customer has.
Correct, Your Honor. And
But you're not willing to reimburse them for that, just your fuel.
Because they would not be able to send that fuel to JEA, and JEA would not be able to provide them with fuel during the nighttime when they can't use their solar power, but for that infrastructure. And that is what...
Counsel, the infrastructure you're talking about, we're talking about power lines, power poles, distribution networks, I mean, a massive amount of infrastructure,
Correct.
right? Someone who produces solar power on the property, I'm not sure exactly what the unit looks like. I mean, it's a solar panel, I suppose, and it hooks into the grid. They don't have, your point you're trying to make is that this overall massive infrastructure that JEA has is substantial.
Correct.
And it's a much larger portion of their overall budget compared to like the fuel.
Correct. I think it is also important to recognize that this statute regulates municipal-owned utilities, which is different than investor-owned utilities. The PSC has decided that investor-owned utilities must reimburse at the retail rate, and but that does not apply to JEA.
Is there a statute that says that?
It's an administrative code rule.
Okay, so it's not in the statute, but so some.
Correct. It's not this statute.
So is it the
And so
Public Utilities Commission that sets that?
The Public Service Commission has
Public
said
Service,
that.
right, okay.
But again, that's investor-owned utilities who, by definition, are trying to make a profit. JEA is not in the business of making a profit. We are in the business of providing electricity and water to the citizens of Jacksonville. And so to do that, our budget has to balance. We don't have investors that we pay back at the end of the day. We need our charter, and 366 has told us that our rates need to be fair, reasonable, and non-discriminatory. And if we pay the solar-powered customers the retail rate, our other customers are going to have to subsidize that. And that would put us in violation of the other provisions of 366 and on our own city charter.
So that's unfair that they have to pay when they don't generate solar power?
It's unfair that the non-solar power customers would have to pay? Yes, Your Honor.
Why?
Because they do not... The solar power customers are getting the benefit of the grid without having to pay for it. And then the cost of that grid, the cost of maintaining the grid and the power
They
lines,
pay just like everybody else.
they being the solar power customers?
Only what they get reimbursed is what they're getting the, quote, free ride on, correct?
I'm sorry, Your Honor, I've lost the train. Are we talking about the solar powered or non-solar
Well,
powered?
you're saying it's unfair to the people who don't have solar power that you are reimbursing the people with solar power at a retail rate, correct?
Correct.
Okay. Why? Why is that unfair?
Because the solar-powered customers are getting the benefit of the energy without the cost of the infrastructure. So without the 70% cost of that fuel, that kilowatt hour,
So were y'all violating your JEA charter originally when you were doing one-to-one retail to retail rate?
I wouldn't say we were violating it, but when it was a de minimis amount, that it didn't have the impact that it does now.
I thought you said it still was a very, very low amount.
The record does not reflect how much, what percentage of
Fair enough.
energy that, so I don't want to misspeak, but it's having enough of an impact that it's causing the rates to be discriminatory at this point, because the solar power customers are not paying, if they are reimbursed at the retail rate, they do not have to incur the cost of the infrastructure of getting the energy from their home back to the grid and from the grid back to their home. That the other customers are having to subsidize that amount, and that's what makes it discriminatory.
Of course, if this is a pure statutory interpretation case, none of this matters.
I would agree
Right?
there.
I mean, we heard from the appellant that this had, all this stuff, all this noise about this and that fairness.
So
It
I
doesn't
think-
matter because in their view, the statute says it's 100% retail rate, period. No, they're not acknowledging any flexibility in JEA's pricing or reimbursement or anything.
So I do think it does matter in terms of looking at the statutory scheme of 366 and how, whether a rate becomes unfair or unreasonable or discriminatory. So I agree, we should first look just to the plain language of 366.91, and that nowhere in it does it discuss retail versus fuel rate. It says that the rate can be offset part or all. Those terms are incorporated into what
Part or all, again, is generation. Is the customer generating just part of what they use? In other words, are they saving 10%, 20%? Or are they generating enough so they don't have to buy any or almost any from JEA? That's a whole different phrase. Part or all, I think, hurts you when you talk about the metering and the billing. Don't you agree, or no?
Well, I think even if we look at the definition of offset, though, offset does not mean 100%. I mean, there's lots of ways I can offset my tax burden.
You
by-
thought it meant offset, you thought offset meant 100% before, and the statute hadn't changed.
But if we look at the statutory scheme in its entirety, in terms of whether the rates have to be non-discriminatory, reasonable, and fair, it's not reasonable to interpret offset as being a one-to-one offset if it would then cause us, because of the growth of solar power, to have those rates not reflect the actual cost to JEA of what it costs to pull that energy from the solar-powered grid, from the solar-powered customers. It may be true that prior to 2018, when JEA was doing a one-to-one reimbursement, that it was so de minimis that it wasn't having the impact that it is now. Doesn't necessarily.
And you say that's not in the record.
What's not in the record is what percentage of JEA's electricity is pulled from solar-powered customers.
Do we know what the change is before JEA changed its program from 100% retail to fuel cost?
So in the record, we have the affidavit of Mr. McInall, who does testify
In
that.
the other case, okay.
Correct. And Mr. McInall does testify that prior to 2018, well, it was really prior to like 2017, that the one-to-one one-to-one retail rate had a de minimis impact on JEA. So we do know that, but then as solar power usage increased, which JEA fully supports solar power usage. I mean, JEA definitely wants more and more customers to use solar power because it relieves the burden on JEA's obligation to generate that electricity, but it has to be fair and reasonable. It can't do it at the expense of other customers who either can't or aren't able to generate power through solar and are still having to pay for that, the infrastructure. I mean, if we take it to an extreme, if all of JEA's customers went to solar and they were all being reimbursed at the retail rate, who would be paying for the infrastructure? There would be no one left.
You want to talk about taking it to the extreme, you could reimburse solar customers at any rate you want from your argument, can't you?
No, Your Honor, because our rates still have to be fair, reasonable, and non-discriminatory. So JEA's board has to approve those rates, and the PSC ultimately has approval over our rate structure, not the rate amount, but the rate structure. So there are checks and balances that would prevent JEA from reimbursing for 1 cent at the kilowatt hour. And JEA has, we know from Mr. McEnall's affidavit, has invested considerable time in determining what that fair and just rate is. How much of the kilowatt hour is consumed by the grid and the infrastructure versus how much of that is actually in the cost of the fuel itself.
Are there any other municipalities or rural electric cooperatives that have this program? I assume there are in the state of Florida?
Yes, Your Honor, my understanding is most of them are, that this is a bellwether case.
Okay, well, that was my next question, which is, I mean, how important is this case to all of them?
It's being very closely watched by the other municipalities because, Orlando, for example, is doing the same thing. I think this case was brought against JEA because, as the appellants identify in their brief, we are the largest municipally owned electric company in the state. And so it would have an impact not just on JEA, but all the other municipalities who are currently reimbursing at the fuel rate.
But this is the only case that you're aware of?
Yes, Your Honor. My understanding is this is the case that's going to test what rate has to be reimbursed at. And if I could just briefly address the quasi-legislative history of the attempted amendment in 2022, I think it's also important to keep in mind that that was driven by the investor-owned utilities who wanted to codify what JEA and other municipalities were doing because the rule that governed them under the PSC did not explicitly had the same language, but was interpreted by the PSC to not allow them to do that. Even though the statute was not amended, it's not even legislative history because it was never the amendment never passed. So instead, we're left with the plain language of the statute as it actually exists, which is silent as to any differentiation between fuel rate or retail rate. Instead, it gives JEA the discretion to develop a net metering program for customer-owned renewable generation that offsets the cost to the consumer, which is what JEA is doing. For these reasons, JEA asks that you affirm the decision of the trial court. Thank you.
All right, I was able to remember your question, and I'd like to start there because it really touches on a lot of what was just being discussed with opposing counsel. Fair, just, and reasonable. These are bedrock requirements of Chapter 366. They were enacted quite some time ago, in the 50s, 60s, 80s. The net metering statute is from 2005, amended in 2008. There was an earlier version in 2005, but really net metering comes from 2008. It's in the same chapter, and it is much more specific. It is a well-settled principle that if the legislature has a more general policy and a later, newer, more specific policy, to the extent that there is any conflict, the legislator intended the later, more specific one to control. However, we don't believe that there is any conflict. We don't think that there's anything that makes JEA's ability to provide rates at a full retail net metering unfair, unjust, or unreasonable. And to that, I would turn you to Florida Rising, Inc. v. Florida Public Service Commission. That's a Supreme Court case decided last year, where the Supreme Court signed off on a $2 billion transfer between different customer classes that was predicated specifically on enabling increased renewable generation on FPL's grid. I would also look at Clay Utilities Company versus City of Jacksonville. That's a case with JEA where they were charging higher rates for customers outside their municipal boundaries, and that was upheld, and the statute that did that was upheld as not violating the fair, just, and reasonable standard under 366 because it was enacted specifically to address a subset issue there that the legislature saw the need to address. And so that's what we're looking at here. The legislature wanted net metering to happen because they wanted there to be additional renewable energy. That does not create a conflict with JEA's general requirement to set fair, just, and reasonable rates. On the basis of the factual arguments about whether this makes it difficult for JEA to balance its budget, I mean, if you adopt JEA's argument, why not say we should just also exempt them from any environmental compliance, any labor and law compliance, I mean, anything that could make it more expensive for them to provide power. This is obviously not what the legislature intends when it says that it wants fair, just, and reasonable rates, and there's no reason to single out the net metering statute alone. On the there was a discussion where opposing counsel was talking about at the end of the month they net, and that is exactly what we have been trying to say the whole time. The whole point of this is that you are supposed to net, and you're supposed to net the energy. So if someone uses 1,000 kilowatt hours and they send 500 kilowatt hours back to the grid, you subtract the 500 from the 1,000, and then you charge them the retail rate, whatever the retail rate may be for that remainder. I mean, that's what the net is. And this makes sense. Net itself is not defined by the statute, so we give it its ordinary meaning. In net metering, we're talking about netting of a meter. If you talk about net income, you're talking about money in versus money out. If you talk about net job growth, you're talking about jobs created versus jobs lost. You're comparing these things on a one-for-one basis. That is just what that means.
Well, you want it to be 1-to-1, but there's other ratios. It could be 50% or 2-to-1. I mean, get back to your statutory. You don't have much time. Your reply so far has been about all this stuff that's not statutory. So to summarize, what's your strongest point on your statutory argument?
I mean, the strongest point is that net metering is talking about offsetting electricity consumption. And the only way that you can offset the consumption is if you are either crediting at the full retail rate, because then you're treating like for like, so you are having the effect of netting it out, or if you do the old school version of this, where they actually had a meter that ran in two directions. The reason that we even are having this conversation is that the modern version of the meter, you basically have a two-channel system, where you're measuring the energy that's coming in from JEA's grid, and you're measuring the energy that's going out. Net metering literally comes from a meter that would spin in both directions at the same exact rate. So kilowatt hours taken.
And then count down, right?
That's exactly right. And at the end of each month, you pay your customer charge, and then you pay the retail rate for the net number of kilowatt hours that you took from the grid. That's what it's meant in every state, the 37 plus states that have adopted net metering, and that's what it means in Florida. I think just to close out, JEA wants to offset value, but the legislature has made clear that it has to offset energy. So the value of 1 kilowatt hour of rooftop solar is a factual question that is just beyond the scope of this proceeding. If that were the issue, JEA could set it wherever they want to, but the legislature made that choice for JEA. They have to provide the full retail rate. Thank you.
Okay, thank you very much. And to both sides, very well briefed and very well argued. We're going to take a short recess, and then we will make our panel change.
All rise.